The current definition of hate speech has been declared unconstitutional. This after ruling on former diplomat and radio host Jon Qwelane's opinion piece on same-sex marriage. The Supreme Court of Appeal says comments can be classified as hate speech only if they cause harm as well as incite violence. Parliament must now amend the vague and overbroad law by reworking the provisions of the Promotion of Equality and Prevention of Unfair Discrimination Act. We need a little bit more detail and meat on this story. So we brought in Steve Letsike, who is the Executive Director of Access Chapter 2. She's also the co-chair of the National Task Team on Hate Crimes, an initiative by the Justice Department. So good to see you. Welcome into the studio.
Thank you so much.
So let's go back to the beginning, because this is a case that's been going on for quite some time.
Right.
In fact, this column was written over a decade ago by Jon Qwelane. So let's remind viewers what was in this piece and sort of what this was all about.
Yeah, no, indeed, Leanne. I mean, this is a very old case. Jon Qwelane published a front cover of a newspaper, predicting a gay man getting married to a goat. And in a way, it's ideally promoting bestiality in this case of a same-sex person in this regard. And I think, that's why we had quite a lot of complaints that flocked in the South African Human Rights Commission. And the LGBTI community, we stood up and said, this is really hate speech. And that is the basis of the case.
Okay, so that's how it all started. Yeah. So what we've seen now coming out of it is saying that the current definition of hate speech is unconstitutional. So what is the current definition right now as it stands?
So as it stands, it's already stating that hate speech, it's a threat or publishing prejudice against a particular group. And in this case, we're seeing that the non-discrimination clause challenged, which is Section 9 of the Constitution, that already promotes a non-discrimination basis. Now, in the case of hate speech, it's cited as a bias act on the basis of a speech. Yeah. So it's a threatening attack.
Okay, and they're saying that this now needs to be amended because, in fact, hate speech is not hate speech unless it incites violence and causes harm on others. Yeah. And this is where the problem comes in, because perhaps the opinions and views of someone can create harm, can incite violence. What do you think now?
You see, the Pepuda clause, this is a Act 4 of 2000, which really speaks about equality in this case. And there are objects of Pepuda in this case. And this is really about how the rights of people cannot necessarily be, undermined, or how a group of people or a person cannot be discriminated. And it is quite clear, and it has been raised in the Pepuda. Similarly, with the part of the object of the Pepuda speaks about the interpretation, and in this case, the interpretation of hate speech. You have to look at the narrative of equality, the narrative of freedoms in a way that does not cite harm or hateful act to any group. Now, in this case, if you look at LGBTI persons, for the hate crimes working group, and there's a campaign, Love Not Hate campaign, that released a study 2 years ago that says LGBTI persons are facing assault, physical and also verbal assault, and 39% have experienced verbal assault. And this is where we are talking about the hate speech perpetrated against LGBTI persons. And what Jon Qwelane has done in his article, it has undermined actually the rule of law in this case, that you cannot speak, attack, or disseminate or write any hateful incite in this case. Yeah. And that's why we're seeing this Court of Appeal judgment problematic.
The actual title of the article was "Call Me Names, but Gay is Not Okay." Even in and amongst all of this, he spoke to how he didn't necessarily agree with former president and the late former president Robert Mugabe's policies, but when it came to his policies on homosexuality, he was in full agreement that homosexuality is just not right.
Yeah.
it's very difficult to understand how this ruling was reached. I mean, what was your reaction when you heard this being handed down by the SCA?
I think, look, this is a disappointing phenomena. You know, I mean, we're expecting a court of appeals judge to protect the rule of law. And in this case, when you speak about human rights, which is enshrined in the Constitution, you know, according to sections of the Constitution, people are privileged on the rights and enjoyment of these rights by virtue of being humans. And we, you know, the judge, Judge Mohammed, has dismissed the idea of protection of rights and fulfillment of rights on the basis of sexual orientation in this regard, and has actually, in his judgment, promoted hate. By virtue of protecting this and saying it's unconstitutional, he has dismissed all clauses of the Constitution in terms of freedom, in terms of equality, but also in terms of non-discrimination.
But let's look at it from another angle, and I'll sort of challenge you on this one.
Sure.
Where does freedom of speech come into all of this? You know, he's not necessarily saying in the article, let's all pick up arms and go and attack the LGBTI community. Sure. It's an opinion of one man. Yeah. Whether you want to listen to him or believe him, that's fine. Or whether you want to close the paper and say, or close the website and say, you know what, this guy, forget about him. I'm not going to listen to him, and carry on with your day.
Yeah.
Are we not entitled to say these things?
You see, rights, everyone has got rights, including those who hold a different opinion. But where rights are hateful to others and inciting hate to others, this is where we speak about responsibilities of rights. And in this case, Jon Qwelane had crossed that line. And I'm not saying that, you know, people's freedom of speech will be taken away, but you need to look at the thin line between what is right and what is wrong. And in the case of promoting and disseminating, both Jon Qwelane and the publication were wrong because they've disseminated information that cite hateful or harmful approach. LGBTI are experiencing high levels of hate crimes in this country, and it is because of this bigotry that is promoted, that is disseminated, that promotes hateful and harmful to them.
Yeah. It's not all lost, though, for you, because... And I've heard some comments from the Human Rights Commission that are actually saying, you know what, this is actually a good thing.
Sure.
Because now we go to the highest court of the land.
Absolutely.
And we talk about this.
Absolutely.
So this is actually not the end, nowhere near the end.
No.
And it's not necessarily all negative for you.
Yes.
So just talk to us about the steps going forward now.
No, indeed. I mean, this is actually good. It has taken our country long. I mean, we have not completed the task of making sure the hate crime and hate speech bill is finalized.
Yeah.
We've been taking it in and out of Parliament for a long time. The previous administration was right at the end where it needed to just make it law, and we did not do that. You know, we missed that opportunity. Now, this approach of taking it to the Constitutional Court, this is the highest court in the land. It really would now finalize a matter that has been standing for such a long time. And it's not just only on the basis of sexual orientation, but on the basis of race, sex, and many other grounds that we need to consider. So it is a good thing that it's going, you know, the intention of going into the Constitutional Court to really make it the last plot. The Court of Appeal could not protect it, but the Constitutional Court, we are guaranteed, as per the rights enshrined in the Constitution, that it will be guaranteed.
Yeah. You know, when you sort of try and rationalize what the SCA were trying to say in this judgment, can you rationalize it? I mean, can you actually think to yourself and say, yeah, okay, no, I understand that. I mean, if I had to sit down and pen an article on, whatever it may be, where it's my opinions, but at the same time, I am hurting a lot of people. Yeah. And because, you know, you as the author are in a position of power, because you, by any given authority, you're in a position of power. If you have a microphone, if you have a pen, if you have been given a platform of any sort, you are in a position of power, and you may be changing the views of other people, or people saying, no, you know what, this is what I've believed all along, and this guy is right, and I feel the same way, and I am going to go out there and create harm. What did the SCA say? I mean, how did they come to this conclusion?
We can't justify hate or unjust system, and not when it comes to people who are affected by the ruling. In this case, the judiciary system's mandate, and in this case, which is the Court of Appeal, you know, we ought to protect the rule of law. And we are very clear, Pepuda, it's one document, it's one act that the Court of Appeal needed to protect, and it left a door of opportunity to attack it on many grounds as well. So what our interpretation, and of course we saw the interpretation of the court of law, of the judge in this case, having denied an expression of promoting, protecting these rights. When you look at the object, again, and I want to emphasize on the object of Pepuda, which is the equality aspect. It's coinciding completely, the linkages between Pepuda and the Constitution, where you ought to make sure that people's rights are protected, they are promoted, and they can be enjoyed. And in this case, LGBTI persons who are human beings, who are citizens of this country, will not be ought to enjoy these rights because of this judgment.
Yeah. Jon Qwelane, is he off the hook? Because I'm reading at this point, he's not necessarily off the hook.
He's not necessarily off the hook. He's supposed to account. And why this matter is going to the highest court of the land, it's really to hold people to account. If we are able to challenge the religious bigotry of fundamentalism, we are able to even challenge journalists in this case, and Jon Qwelane had crossed that line.
So his comments after all of this saying, Qwelane speaking through his attorney, this was in the Sunday Times newspaper, saying that this is one of the greatest things to happen to free speech in this country's history, equally the freedom of the press. Qwelane said it was important for press freedom. He said he never called for the harming of anyone and never would. That's his stance, obviously, on this ruling. This is the greatest thing to happen to press freedom in the country.
Like many of the leaders that we have, people do not call for harming, but the laws that are put forward, the written responses and publications that are put, promotes the harmful approach. Anyone in communities that read that, because messages in newspaper or on radio, on TV as we're speaking, it's really about how do we promote hateful, and in this case, the promotion of hateful or harm to the LGBTI community was incited by the article written by Jon Qwelane.
I mean, if we look at previous cases before where people have written racist things, racist articles, racist social media posts, and some people have been held to account and others have not.
Yes.
What does that mean? I mean, if we're now saying we're all entitled to freedom of speech, so I can write a racist article, I'm not asking you to go out and be racist and harm people, but that's my opinion. Is that now allowed under this ruling?
It is not allowed, Leanne.
But under the ruling, is it allowed?
You see, Leanne, we need not to run away from the responsibility. Rights come with responsibility, and all citizens have got that. Yes, those who would have gotten away with that, they were not put to book or to task. But we cannot accept that if matters that are public in our face should not put to task. And this matter, and like many other matters we've taken in the past, and not only just for Jon Qwelane, but even with media people, we've taken these matters to task for accountability. Where responsibility lies is where we need to act responsible. And we have not done so. But we are putting the courts of appeal process in place to make sure that the accountability of the law, we are putting the Constitution at task. This is part of democracy, and it must be acted on.
Yeah, indeed, but not to the detriment of South African citizens.
Absolutely.
And to hurt people in an unnecessary manner. Steve, we are not going to leave this. We'll follow it all the way through. As you say, it's not over. The next step, of course, is the Constitutional Court. And this now opens up the discussion, a much needed discussion, as you've been saying, with regard to this clause in the Constitution, which we might see what happens now. So, Steve Letsike, always a pleasure speaking to her from Access Chapter 2. And this is all about the Supreme Court of Appeal's judgment declaring the current definition of hate speech as unconstitutional. All right, let's leave it there. We'll be back with you, the news at